Good morning, one and all. Apologies for the slightly tardy beginning here. This is our Federal Affairs Advocacy Task Force, and the first item of business is to establish the presence of a quorum as we call the meeting to order. So let me turn to the clerk and ask her to call the roll.
Vice Chairperson Lee
Good morning, President.
and Chairperson Simitian.
Here.
Thank you. You have a quorum.
Thank you very much. That takes us to public comment, which is that portion of our agenda set aside for comment by members of the public on non-agendized items that are properly within the jurisdiction of this committee. Let me ask the clerk, do we have anyone here in chambers who has submitted a card and would like to speak?
We do not have requests to speak either in person or virtually.
All right, thank you very much. That takes us then to item number 3, which is to approve the consent calendar. And Supervisor Lee, the only item on the consent calendar, items, plural, forgive me, are our minutes from prior meetings. Can we get a motion to approve the consent calendar?
So moved.
And I will second that. Let me check with the clerk, see if we have anyone who wants to speak to the approval of the consent calendar.
There are no requests to speak.
Thank you. Then let's call the roll.
Okay. Vice Chairperson Lee
Aye.
and Chairperson Simitian.
Aye.
Thank
Thanks
you.
very much. That takes us to item number 4, which is to receive verbal reports from the chair and the vice chair relating to items of interest to the task force. I have no verbal reports, oral reports today. Supervisor Lee, anything you want to just share?
Not this morning. Thank you.
Thank you very much. Then we will move immediately to item number 5, and we'll go to County Council for the County Council's report relating to items of interest to the task force. And the item indicates a couple of areas where we have had a continuing interest. And we'll turn to Ms. Press. Thank you.
Good morning, Chairperson Simitian, Vice Chairperson Lee. Just to give a brief update on these matters. So first, we're going to lead with the Alliance for Hippocratic Medicine versus FDA and related cases. As followers of this task force will remember, these are related to the series of challenges around the nation to the availability of mifepristone. And again, just a little bit of background, mifepristone was approved by the FDA as a drug, eventually part of a 2-drug regimen for medication abortions. The other one, I believe, is called misoprostol. All of that was sort of moving along without any hitch for literally decades. And then just recently, back in 2022, this group called the Alliance for Hippocratic Medicine brought a challenge where they said the original FDA approval back in the year 2000 was something that they thought was unlawful and should be enjoined. And then there have been a series of dispensing and prescribing changes over the intervening decades. They sought to challenge those altogether. Back in April of 2023, a federal district court in Texas accepted the challengers' theories in total and enjoined essentially everything about mifepristone, the FDA original approval, all of the dispensing changes, all of that was enjoined. Left undisturbed, that would have meant that, effectively speaking, mifepristone would have been unavailable and for use in the United States. However, shortly after that district court decision issued, it was immediately taken to the Fifth Circuit Court of Appeal, which issued a stay. And then at this board's direction, that we, working with the City of New York, we filed our very first amicus brief advocating for a stay in that instance, but also speaking to some of the larger issues. The Fifth Circuit took a look at it and they said, well, I'll tell you what, we're gonna stay longer term the issue about whether the FDA properly approved mifepristone back in the year 2000, but we're gonna let the district court order enjoining other prescribing and dispensing changes, we're gonna let that part of the injunction stay. And part of that, why it was so alarming, is one of those prescribing changes both changed the time frame, how many weeks into a pregnancy mifepristone could be used, It also affected the earlier action that the FDA took was to eliminate the in-person dispensing requirements. So in other words, all of these changes, relaxation, if you will, of dispensing requirements that had occurred for years were suddenly now on hold. That order from the Fifth Circuit then was taken up to the U.S. Supreme Court. Once again, at this board's direction, the county counsel's office, working with the city of New York, filed another amicus brief. And in that instance, that was in late April of 2023, the Supreme Court then stayed the entire action, all of the earlier decisions, pending a return of the case on the merits to the Supreme Court. That ultimately occurred later in the year. The Fifth Circuit issued more of a merits decision where it basically mirrored its earlier decision, saying the original approval of mifepristone by the FDA was okay, but still upheld the injunctions as to the dispensing changes. So that went up to the Supreme Court. Supreme Court issued its decision on June 13th of this year, after, of course, our last April meeting of this task force, so we haven't yet reported on it formally to this task force. And in that decision, which was unanimous, incidentally, and authored by Justice Kavanaugh, the Supreme Court ruled on I think what most lay people would call is a technicality, finding that the plaintiff doctors and their medical association lacked standing, meaning that they were not the right people to bring the challenge against mifepristone, precisely because a few things. One is that it was established that these doctors didn't prescribe mifepristone themselves for their own patients, didn't use mifepristone, and even if they encountered patients who had used mifepristone, who somehow came into their practice for whatever reason, they could exercise their rights under the so-called federal conscience laws to literally opt out of caring for people who had used mifepristone. So the Supreme Court said, at the end of the day, frankly, these plaintiffs and their medical association, they are not even regulated parties because they don't use, don't care for, have nothing to do with mifepristone. So easy out for the court, if you will, but it left some uncertainty for the rest of the nation, given that certainly a party that could establish standing could be able to revive the lawsuit and ultimately challenge some of the aspects to mifepristone. So that is the status of the Alliance for Hippocratic Medicine case. Again, overall takeaway is that mifepristone remains as available in the various states as it was prior to the Texas District Court injunction issuing. Question?
Just that being said, the underlying issue, it remains unresolved, and continued access for those who want it could appropriately be characterized as at risk, yes?
That's correct.
Thank you.
And sort of foreshadowing that, the Supreme Court decision closed with a notation that perhaps these things will be resolved by the political and democratic process. As we know, there are a number of states that already have or presently have referenda about establishing or reestablishing constitutional rights to abortion access in various states, but that is a state-by-state solution, not a nationwide solution. While all of this was happening, there were two other lawsuits that were happening, going on around the nation. One in particular that I know we've talked about before is called State of Washington versus FDA. This was a different kind of lawsuit. It was brought by 16 states and the District of Columbia. California chose not to join that lawsuit, and its significance I will explain in just a moment. This was a different kind of lawsuit in that even though the target defendant was again the FDA, in this instance what they were saying is, FDA, we think that it was fine with the approval of mifepristone, but its challenge was based upon saying that the restrictions, what's called a risk evaluation and mitigation strategy, or REMS, that this sort of scheme that governed how mifepristone could be prescribed, which pharmacies could actually dispense it, and even adding some obligations on behalf of patients, that this, generally speaking, restrictive scheme was arbitrary and capricious. What they noted in that lawsuit was only 60 other drugs nationwide are covered by such a REMS scheme. Some of those include fentanyl, whereas other drugs are not covered by REMS. One example they pointed out was Viagra. And so what they said in this lawsuit was that it was arbitrary and capricious for the FDA to impose this really restrictive scheme on mifepristone. It just didn't warrant it. It's been in use for 20 years. Over 5 million people have used it safely. It just wasn't in that type of class. That case was sort of moving along, and then suddenly on the same day, when the federal district court in Texas issued its injunction against the FDA approval of mifepristone and also blocking the other dispensing regulations, 1 hour later, this Washington federal district court issued its ruling, and rather than throwing out the REMS or blocking the REMS restrictions, it just said the FDA shall not impose any further restrictions on the access or prescription or dispensing of mifepristone, but at least for the 16 states and the District of Columbia that were part of that Washington lawsuit venued in the Eastern District of Washington, they were actually not covered by the district court case from Texas. So it was this very odd patchwork where if you'd happened to be part of the Washington case, you were protected in a different way than you were if you were not. So as I mentioned earlier, California did not join the Washington case, and therefore we were reliant in California on the fate of the Alliance for Hippocratic Medicine case. So that case is now currently, the Washington case is currently being briefed sort of in response to what has happened in the U.S. Supreme Court. A number of states have sought to intervene in that Washington case, but to date, their efforts to intervene have been rebuffed. Question? Nope.
Thank you.
All right. One more on the mifepristone front. Another case called Whole Women's Health versus the FDA. This is filed in a Virginia district court, also filed in 2023. This was also a sort of defensive response to the Alliance for Hippocratic Medicine case. And again, this was a response in that this was brought by some states that were also not covered by the state of Washington case. Actually, I'm sorry, this was not brought by states. This was brought in on behalf of patients in states of, but not brought by the attorneys general of these states. But for the states of Virginia, Montana, and Kansas, a group called the Center for Reproductive Rights brought this lawsuit on behalf of specific abortion providers in those states. And basically, this case has kind of stalled out. It's undergoing briefing at this point, but no orders have issued that in any way are protective in this case. The court basically said, right now, your target defendant, the FDA, has clearly signaled in its other lawsuits that it's not going to be doing anything, especially in light of the Supreme Court case, to restrict access to abortion. So again, back to your original comment, Supervisor Smidian, the overall takeaway is that despite this flurry of procedural and frankly significant clinical uncertainty about the fate of mifepristone. The access today is the same as it was prior to the federal district court issuing its order more than a year and a half ago, albeit that, of course, one's reproductive rights, unfortunately, because of the Dobbs decision, now do vary significantly by state, and that is still being settled. So that is the current status of the mifepristone cases. Obviously, a lot more to come down the pike on that.
Thank you. And speaking of Pike, I should have mentioned Tom Pike is here with us today from, couldn't resist, Tom, sorry.
Very good.
From Congressman Ro Khanna's office. As always, we appreciate Tom's presence and the Congressman's willingness to have you join us. And I also would note Mr. Campos from the County Executive's office is with us here at the dais. Anything, and let me just look to Mr. Margolin. Mr. Margolin, are you just teed up for the next item, or, okay, thank you. And quick comments or questions from you, Supervisor Lee?
First, I want to thank our County Council's office for doing such a thorough job on the very complicated and convoluted analysis of these cases relating to mifepristone. But I think to sum it up, the Reader's Digest version, as they say, is that there has been no change.
That's correct. From a federal level, but again, one has to check as to which state you are in, which state you are seeking care in, because that landscape is more rapidly changing. But in California, status quo.
Great, thank you.
Thank you. Any other items at this time, Mr. Press?
Yeah, just want to cover two other matters. One is, I know at an earlier federal affairs meeting, I think it was the November meeting, we talked briefly about what's called Chevron deference. That case was also decided on June 28th after our last meeting. This was a 6-3 decision. Chevron deference, as you may recall, it's about, it's an interpretive doctrine that the Supreme Court declared in a case from 1984, Chevron versus Natural Resources Defense Council. And in essence, Chevron deference means that if you have an ambiguity in a statute, look to the federal agency that has jurisdiction to implement or enforce that statute. If their interpretation of that ambiguity or gap in the statute is reasonable, then the courts are obligated to adopt and go with that interpretation. The court, as I think they've been signaling for some time, were quite suspect of Chevron. In fact, the U.S. Supreme Court hadn't really relied on it for a number of years. And so they put the proverbial final nail in the coffin in a 6-3 decision where they said Chevron was not entitled to, was overruled, declaring it to be, quote, fundamentally misguided, which again, query whether what the practical impact will be from this decision, other than to signal some significant, and I would say ongoing, for lack of a better word, hostility from certain parts of the federal government about the administrative state, something that we've seen many times before in the past, but this has gone further than it has ever.
Mr. Press, excuse the interruption. To you, when you mentioned what the practical implications are, sort of putting aside ideological doctrine or legal doctrine as a practical matter, and I know different folks have different points of view about the extent to which it's, quote, appropriate, never mind lawful, or desirable for the agencies to weigh in as robustly as has historically been the tradition. But it strikes me as I listen to you that the practical implication in the years ahead is likely to be a legal requirement, a need for matters that have historically been dealt with at the agency level to be dealt with legislatively. Does that sound right?
That's correct.
And it strikes me again, just as a practical matter, that given the relative division in both the House and the Senate in recent times, that's going to be tougher to achieve than it might have been at a different time. And you can argue good, bad, or otherwise, but just so we're irony of ironies, we're entering a time when the court has effectively asked for the legislative branch to step up and step in and do that work rather than abdicate that role to the administrative branch. But that's happening at precisely the time when the legislative branch is frankly struggling to find common ground in a lot of areas. All right?
A new form of gridlock, perhaps.
Yeah, no, that's
Yep.
that's what I'm trying to anticipate in the next 2, 5, or 10 years. So, all right. Forgive the interruption. Keep rolling.
Yeah, no problem. As I think I may have mentioned several task force meetings ago, if you look at our very lengthy grid, it was declining in volume for a period of time. Now it's going in the opposite direction. That most of the matters discussed in that grid are regulatory challenges. So that, I think that, again, gives you a flavor as to the overall trend. One of those regulatory challenges are the 2024 Article 9 regulations. You may recall we've discussed this in quite a few task force meetings in the past. And just to give the update on that, so there were the Trump administration revisions to the rules implementing Title IX that caused a great deal of, frankly, heartache for a lot of folks in that it changed what would be the subject of a university's jurisdiction, for example, over certain harassments or assaults. For example, just one that stands out was it redefined certain off-campus activities as being outside of the jurisdiction of a college or university. It also had some different changes that made it more difficult for survivors of sexual assault or harassment to have to come to an administrative hearing and be in the presence of their accuser, things of that sort. The Biden administration did a fundamental rewrite of those rules, and those rules, they issued in April. I think they were supposed to be effective in August of this year. I believe the count is up to something like 10 different lawsuits have been brought around the nation against the rules. A number of those have halted the rules in their entirety. But the news on this is troubling and a little bit misleading. On the one hand, you could read some of the articles saying that the 2024 rules are only enjoined in 26 states, and in 24 others they can go ahead. But in particular, there is a federal district court case brought in the state of Kansas versus U.S. Department of Education, that was brought only on behalf of 4 states: Alaska, Kansas, Utah, and Wyoming. But here's the tricky part: the court in that case issued what some commentators have described as a quote-unquote unique preliminary injunction, in that while it wasn't labeled as a nationwide preliminary injunction, what the court there said is, in order to provide relief, the three plaintiffs groups that also brought the case, Moms for Liberty, Young America's Foundation, and Female Athletes United, what the court said was, in any state and for any school covered by Title IX, if any of these organizations' members or their members' children attend a school, that school is also enjoined from relying on the 2024 rules, and therefore by default has to follow the 2020 rules issued by the Trump administration. To give you a sense of the reach of that, even though California as a state is not enjoined from applying the 2024 rules, just in Santa Clara County alone, Stanford, Santa Clara University, San Jose State, Mission College enjoined. A number of high schools, American High School, Independence, Irvington High, Los Gatos High, Milpitas High, Palo Alto High, Saratoga High, Washington, even middle schools and some elementary schools. So it is and no relief has been obtained yet from the scope and reach of this order. But the overall takeaway on this particular issue is 700 schools nationwide are covered by this Kansas District Court order, and the list is growing because the plaintiffs and the defendants in that case are currently battling whether the list is even permitted to grow during the pendency of the lawsuit. So really unfortunate and complicated set of circumstances in that case. Yes. Questions?
So this is a decision from which court?
Kansas District Court.
Which now has affected not just Kansas, but the entire United States schools
That's
on
correct.
this ruling.
700 schools, universities, colleges, community colleges, high schools, middle schools, elementary schools, whatever is touched by Title IX funding.
And this will be up on appeal, but there's nothing being enjoined right now for
Correct.
the.
Yeah.
Is this something that a government body like us or school district could actually file something to appeal this ruling?
Don't believe we've received authorization to weigh in on this particular case yet.
Yeah, let's follow up on this issue because I think this is something that a district court, I mean, fairly low level on the scheme of things, that made the decision that is now affecting us here right in California with the number of schools you mentioned is frankly ludicrous. So yeah, let's look into that one, please. Thank you.
Mr. Press, forgive me, and if this is something that's not your bailiwick, I will understand. We can get an answer or something later. You may or may not recall, we had a conversation at the board about essentially retaining counsel and or contractors to perform an audit of not just schools but other public agencies in Santa Clara County on the issue of Title IX compliance. I think that was in, I want to say October of 2020, if I'm remembering correctly. And it then ran into some headwinds in terms of some back and forth about finding a qualified contractor and or law firm. Can you remind us where that stands, if you know?
Candidly, I don't know the current status, but I'm happy to get you a confidential off agenda on
Great,
that.
if you could do that for us, I would appreciate it. All right.
Without any other questions, that's my report.
All right. Let me just double check and see if we have any speakers on this item. Don't believe we do.
No, we don't.
Thank you very much, Madam Clerk. That then takes us to item number 6, which requires just a little bit of explanation. This is our federal health policy, and why don't we actually, even though we don't really need to take formal action, I'll ask for a motion to receive the report from County Council before we move on to the next item.
So moved.
Motion by Lee, second by Simidian. No speakers. Call the roll.
Vice Chairperson Lee?
Aye.
And Chairperson Simidian?
Aye.
Thank you.
Unanimous vote. Report's received. That'll give the clerk a good, clear record going forward. It does take us to item number 6. This is the Federal Health Policy and Budget Landscape Report. And I think we're going to start with Mr. Campos, who's then going to move us along to Mr. Margolin and or others. But I just want to clarify, we're going to take this matter up this morning, notwithstanding the fact that the Health and Hospital Committee meets later today. And Supervisor Lee and I are the 2 members on Health and Hospital as well. So we're kind of doing double duty. And for Brown Act open meeting compliance purposes, the meetings are noticed as essentially overlapping. So, Mr. Campos, to you.
Thank you, Mr. Chair, Chair Simidian, Vice Chair Lee. Good morning. David Campos, Deputy County Executive. It's good to see Mr. Pike from Mr. Khanna's office. Before I turn it over to Mr. Margolin, just want to provide some context. In the next item, you're going to hear from Prime Policy on larger federal budget issues, and we will also have a conversation about the FEMA reimbursement. As Mr. Park knows, Congress was on summer recess from July until the week of September 9th. And we simply note that we're all watching because the end of the fiscal year is about to happen at the end of this month. And so far, the spending bills have not been passed by Congress. So that's something that we're all carefully watching, and that will have implications on a number of things. With that, I'm here joined by Bert Margolin of the Margolin Group, and he's going to provide an update specifically on federal health policy and budget issues relating to that area. So, Mr. Margolin, thank you for being here, and I'll pass it on to you.
Thank you very much, Mr. Campos. Good morning. Let me begin with an update on the health funding issues that are linked to reaching a budget agreement in D.C. before the end of this month. As we've discussed in the past, there are three issues we've been tracking in particular that are of consequence to the county. The deferral of the scheduled cut in DISH funding, the extension of community health center funding, and the extension of telehealth flexibility in the Medicare program. All need to be acted on by the end of the year. There is more or less a bipartisan consensus on the need for action on all three of these items. There are some details still being negotiated, but pretty much a consensus on the substance. And there's a working assumption that they should be part of the budget agreement. That's sort of where we are. I will leave it to Prime Policy when they make their report to discuss the dynamics driving the budget negotiations. But the short version for now is that the key leaders on all sides want to avoid a shutdown. No one wants that. There's the potential for miscalculation always. Shutdown is not totally off the table. But everyone more or less expects a short-term CR with the end date most likely occurring during the lame duck session. That's sort of the conventional view. And again, Prime Policy will enlighten us more fully on that process. Another issue I wanted to update you on is the issuance of the final rule enforcing the Mental Health Parity and Addiction Equity Act. Parity for mental health services has been a key priority for Santa Clara County, as we all know, for some time. The law calling for parity was passed in 2008, but real-world implementation has been not fully successful for a range of reasons. There's a large gap still between the way insurers and health plans treat physical health issues and the way they treat behavioral health issues. The Biden administration sought to address this with the latest regulation, which they began working on a few years ago. It was just issued in final form last week on September 9th. It impacts three departments of the federal government, Labor, Treasury, and Health and Human Services. That has to do with the fact that insurers and health plans are regulated by different agencies, so in different departments. The Department of Labor official who announced the new regulation made the point that mental health and substance use disorder benefits should not come with any special roadblocks. It shouldn't be harder for you to get care when you feel depressed than when you feel back pain. That's the basic premise behind these regulations. They make a number of technical changes in the way health plans and insurers have to operate in the realm of parity. They will need to assess their provider networks in more detail and with greater rigor. They'll have to look at how they pay out-of-network providers, how they utilize prior authorizations. Basically, the reg says that you can't use more restrictive prior authorizations or narrower networks for mental health than for physical health. The term of art that's referred to in the regulation is non-quantitative treatment limits. Basically, it's not about whether you spend the same amount of money or you have same reimbursement rates. It's about these non-quantitative issues such as prior authorization. How many hurdles do you have to jump over in order to access care? Do you actually have a provider network that realistically gives someone who needs substance use or mental health services access to those services? The rule also closes a loophole in the 2008 law that exempted non-federal government plans, there are some 200 nationally, from compliance with the parity mandate. There will be, because of this rule, new data compiled, new analysis available publicly. It will create competitive and public pressure for compliance with parity. There doesn't appear to be much in the way of significant new teeth or consequences for failure to comply. So this is not a cure-all on parity. I don't want to oversell what the regulation means, but it will put more pressure on plans that are not complying with parity, and it will move the debate along. While parity has been a bipartisan issue in the past, Republicans in the House are, for the most part, opposed to this rule, arguing that it's creating new paperwork requirements, and the health plans themselves have said they will push back on the rule, which might mean litigation down the road. I also want to spend a few minutes highlighting how the debate over health care in the presidential election campaign and in the Senate and House races is playing out, and the implications for that for next year when it comes to federal health policy, what's likely to happen next year. If Kamala Harris wins, it's pretty clear that her administration would focus on strengthening the Affordable Care Act, making sure that the exchange subsidies that were passed as part of the Inflation Reduction Act to make coverage more affordable, make sure that they expire next year, make sure that they're extended, and that other efforts are made to enhance affordability within the context of the Affordable Care Act, covered California, the health care exchanges. As we saw in the recent debate, former President Trump has softened a bit on his prior insistence that the ACA had to be immediately repealed. He said he would want to have a plan first. Right now, per the debate, he's at the point of developing the concept of a plan. We aren't quite at the plan point yet, but that's what he said he'd want to do down the road. It's useful to remember that repeal failed in 2017, 2018 during that first Trump administration because Senator McCain and a handful of other Republicans basically said, without an effective replacement, we're not going to repeal the plan. And they were focused on pre-existing conditions being protected. The effort to repeal did not guarantee that people with pre-existing conditions would not in fact lose coverage, so the effort failed. This time, so there is this there is this shift in focus away from ACA repeal on the Republican side, but there is a growing consensus on another agenda, and which wasn't talked about in the presidential debate, but it's very much part of Project 2025, and it's very much part of what the House Republicans have developed in the way of their own policy plans should they take control of the government next year, and that is scaling back the Medicaid program. Republicans have criticized Medicaid spending growth as a major problem for some time now, and they would likely prioritize revising the debate over either creating a block grant system or a per capita cap system. Both mechanisms are ways to slash spending on the Medicaid program based on formulas tied to metrics such as population and not really linked to the need for services in a specific state. The Republicans also want to increase the use of work requirements in the Medicaid program, something that the Trump administration attempted when Biden took office. They reversed all of those Medicaid waivers that called for work requirements, again, believing that it was a device for restricting access to the Medicaid program. Republican plans also include eliminating the enhanced federal match, 90% match, that's been used as a carrot to get states, many of them red states, to expand the Medicaid program pursuant to the ACA. It started out at 100%, it went down to 90% match, but it's still a very generous match, and they would like to get rid of that. Again, these ideas are outlined in Project 2025, and the Republican Study Committee, the largest Republican caucus in the House, which has more than 170 members, this is sort of the bread and butter of what they want to do on health care next year, should they control the government. Now, in addition to this being sort of mainstream Republican thinking, there's one other reason why an assault on Medicaid next year is likely to occur. And again, in 2017, it didn't happen with much fervor because the bigger goal was ACA repeal. Medicaid was a subset of that. This will be front and center, not only because it's a matter of consensus on the part of Republicans, but the number one goal for most Republicans next year will be extending the Trump tax cuts. They have to be paid for, and Republican strategists and policy thinkers are more and more focused on curbing the Medicaid program as a way, as a partial way at least, of getting the savings they're going to need to extend the Trump tax cuts. So again, this is a little preview of a debate that we may have next year, depending if the Republicans take control. And again, it'll be, I think, a serious debate if they're in full control of the government because they're incentivized by their desire to extend those tax cuts. The last item I want to touch on is the MCO tax debate, which is also a federal issue because we have these multiple billions of MCO, managed care organization tax dollars available for the Medicaid program because of a federal state agreement on how Medicaid matching, the Medicaid match operates. The MCO tax has been around for a long time. In the past, prior to the current debate we're now having, it was used almost exclusively to reduce state deficits. What's different about 2023 is that we now have an effort to not only reduce the deficit, a portion of the money still goes for that purpose, but we have an effort to actually fund Medicaid providers and address the woeful underfunding of our Medicaid program in California. There's about $7 to $8 billion in net benefit generated per year under this MCO tax. And in 2023, the governor and legislature came to this grand agreement on a portion of that being used for deficit reduction, but the bulk of it being used, or initially a big chunk of it, and ultimately the bulk of it being used to give providers more funding so there'd be better access for Medi-Cal beneficiaries. A large coalition of groups, provider groups, California Hospital Association, Planned Parenthood affiliates, came together not only to negotiate that initial deal in 23, but also to put together an initiative for the ballot, Prop 35, which was designed to kind of memorialize the agreement that we're going to spend this money on healthcare providers and the needs of the Medi-Cal population, not just on reducing the deficit, and put that into an initiative so that it would be guaranteed going forward, along with a requirement that the state not allow this MCO tax to expire in 2026, the current plan, but would seek approval of an extension through 2027 and beyond. The initiative became much more of an urgent issue for the healthcare community in June when the governor, facing this massive budget deficit, decided to take away most of the money, not all of it, but most of the money that was previously dedicated to public hospital systems like ours and other Medi-Cal providers. There was still money left in the budget, but it was a small fraction of what was originally there, and it was for, in many cases, other providers who have good arguments to make. They have needs as well, but it was a smaller chunk of money redirected to other purposes. So along comes Proposition 35, which initially was going to be sort of the safety net or guarantee that this would not be diverted in the future. And because it was diverted this year, the Prop 35 debate has taken on greater urgencies. If Prop 35 were to pass, public hospital systems such as ours would receive access to a dedicated fund of $150 million per year. We would also have access to other funds that for emergency department services, specialty care, and many other services outlined in the initiative. So there's a lot at stake in this debate. I wanted to just remind members of the committee that this is another federally linked issue that's playing out in real time over this month and next month. That completes my report. Happy to respond to any questions you might have.
Thank you. Supervisor Lee?
Thank you so much, Ms. McGowan. As always, a very comprehensive report. This is a question actually with our wonderful Dave Campos regarding the issue of various propositions. Remind me, in Prop 35, have we taken a position on this already as a county?
Yes, through the chair, Vice Chair Lee, the board has taken a position to support Prop 35.
Great. Okay, so that's only something that we would like to go and support. Now, that being said, I think the takeaway I did receive from you is regarding the issue of the threat to Medicaid is something that we need to be aware of. The proposition that will likely move forward in the future is that in order to pay for, you say, the tax cut from the Trump era, in order to pay for those tax cuts, in this case, tax cuts mostly the funding will be from the rich, through cutting the Medicaid funding. And as I understand, Medicaid is more like providing funding to help the poor who cannot afford insurance. So basically, in short, it's like a reverse Robin Hood here, right? Trying to cut funding for those who need it most, who are poor, and then just use that to pay for the rich.
I mean, that is an analysis that has validity. I'm sure the Republicans will be looking for other funding sources as well, and they haven't formally put out their plan yet. I'm giving you the benefit of the current thinking of people in this arena about what's likely to happen next year. There's not a guarantee they'll go that route, but your analysis would be a valid analysis if that were to be their strategy.
Good. Thank you very much.
Thank you. Mr. Margolin, and to our own county staff, both county council and county executive's office, I just wanted to take a moment to underscore our county's interest in and support for mental health parity efforts. And I know you know that it's been an issue of particular interest to me, and I've done some board referrals on the item. Mr. Press, you've worked on the issue with my office. Thank you for that. And I'm raising it up because Mr. Bergeron, I can't remember your exact words, but essentially I inferred that there was sort of some uncertainty about just how effective some of these efforts would be in actually addressing the issue. And I'll just say I think we have decades of experience that no matter what happens, whether it's legislative or otherwise, it's been a struggle. And the reason I'm raising the issue is while my office and I have tried to provide some leadership on this issue, it is an area where the full board has weighed in unanimous support, and so I just want to, as I make my way off this stage, want to make sure that county staff, including our consulting team, understand the importance and the support that is there for the entire board. I would hate for us to have a window of opportunity and not jump right through it and run as far and as fast as we can, whatever opportunity that may or may not be. That's really all. Mr. Campos, I see you leaning in.
Just a couple of points, Mr. Chair, through the chair. We understand that direction and have actually been very active at the state level. As you know, we co-sponsored two bills, SB 294 by Senator Wiener and AB 3260 by Assemblymember Pellerin that tried to move forward the issue of mental health parity. Those two bills unfortunately died in the Appropriations Committee in the state legislature. But we are very clear that this is a big priority for the entire board. I want to acknowledge in the audience Elaine Trin, who just took over a new position, a program manager, to focus on federal legislative matters, and this is one of the things that we will be pushing at the federal level moving forward. So we get the message and look forward to continuing to partner with your office and the entire board on this critical matter.
Thank you, and forgive me for being a little bit flip, but the Appropriations Committee is where all good bills go to die, and I have some personal and painful history there as well. All right, anything else Supervisor Lee on this item?
No, that's all I have. Thank you very much.
I'm going to ask for a motion to receive the report.
So moved.
I'm going to second it. I'm going to ask the clerk if we have any speakers on this item.
We do not have
We
requests. to
do
speak.
not, and we'll say thank you for the report and call the roll.
Okay. Vice Chairperson Lee?
Aye.
And Chairperson Simitian?
Aye.
Thank you.
Report is received unanimously. Thank you. Thank you again, Mr. Margolin, and you'll stay put. Mr. Campos, do we look to you to provide the lead-in for item number 7, our next federal legislative, regulatory, and administrative climate report?
That's correct, Mr. Chair. Again, David Campos, Deputy County Executive, and we have the prime team that I will be presenting shortly. But before I go to Prime Policy, who represent us at the federal level, I want to just provide some information about the FEMA, Federal Emergency Management Agency reimbursement effort that we have undertaken. At the beginning of the calendar year, the county executive directed the IGR team to work closely with our finance agency, in particular Margaret Olea, Maria Oberg, and Robert Fannion from the county counsel's office, and asked to develop more than just the concept of a plan, but actually a plan for engaging our federal government on those reimbursements. And the strategy that we undertook engaged the congressional delegation. I see Representative Khanna's office, Representative Lofgren as well, Panetta and Eshu have played a key role. We have also reached out to the White House, and as of the end of last calendar year, before the beginning of this year, the county submitted about 480 plus million in claims from FEMA. I would note, by the way, that the county actually spent 3 times that amount, about 1.5 billion, in response to the pandemic. About a third of that was eligible for federal reimbursement. More than 80 claims, 89 claims. And as of the end of last calendar year, we had received about 55 million in obligations of that 480 plus million. And happy to report that because of the work that we did with our congressional delegation, with the White House, in the last few months, we have received more than 200 million additional obligations from the federal government, which means that about half of the claims remain. And not only have we received the obligations, we also requested and have been given by FEMA and the state agency Cal OES a process where they meet with us every other week to go over the remaining claims, prioritizing those claims that can move forward. We actually have the largest number of claims of the more than 3,000 counties in the country, so you can imagine that that's a challenge, but we're very grateful and happy where the process, where things are. There are 2 challenges that we're facing in this context. One, at the state level, the way the claims work is that once a claim has been obligated, it then goes to Cal OES, which then has to process the claim. They have been very responsive. They're part of this team that meets every other week, but you only have a handful of folks that are responsible for processing these claims. And as you can imagine, you have a lot of FEMA claims throughout the state of California, and now with the number of fires that are unfortunately taking place, that could be an impact for us. So we are now focusing on getting that 200 plus million that has been obligated in the last few months processed so that we can receive it. With respect to FEMA, we continue to work with FEMA and Cal OES to get additional claims obligated. But the way that the process works, FEMA was given money, but it ran out of money. So unless there is a continuing resolution that includes additional FEMA funding, no additional claims will be obligated going forward until that happens. So what happens in Congress in the next few weeks, in the next few days, is really critical because FEMA needs additional funding to be able to obligate those claims. So that is the gist of where we are. And again, really grateful for the work of the IGR team with Elaine Trin leading that effort on our end, as well as the finance team, and, we'll continue to push, but I'll turn it back to the chair in terms of questions that you may have.
No questions at this time. Supervisor Lee, I see leaning in.
Thank you, David, for the I would say semi-good news. The semi part being the fact that we have all received over 200 million from the federal government already. Thank you, and thank you for Ro Khanna, Congressman and his folks in DC pushing forward to make that happen. I want to give the credit where the credit is due, along with our other Congress members from the Bay Area that has been helpful, like Congresswoman Inishu and also Zoe Lofgren as well. That being said, the problem now on those 200 million is no longer federal government, is the state. And as David, you mentioned, there are only a handful, like not enough people to process it at Sacramento. So my question here is, number one, every day we don't get the money, the interest on $200 million is lost, because this is something the state does not pay us back on. So what would be the incentive for us through our state delegation we could use to push forward to receive this funding sooner, because it is our money?
So we are closely monitoring the situation, and in fact, we plan to have a meeting with our delegation, our state delegation, next month in October to update them and provide a briefing on the regional, the purchase of a regional medical center. As part of that meeting, we will have a specific ask in terms of Cal OES. We're trying to ascertain what that ask is, because again, we are very pleased and happy with the level of attention that has been given by the Cal OES staff, who have been, really extraordinary in terms of moving money forward. But we also want to support them in their own limitations. So we don't have a specific answer yet, because we're trying to figure that out, to make sure that it's the right ask in terms of our delegation and in terms of the administration. But we have approached this process from the perspective that we have a very small window during which we need to get the maximum amount possible from the federal government, because we don't really know what's going to happen in November. And so we believe that our best chance of getting reimbursed is through the existing administration, and that's why there is a sense of urgency with both the federal and state level, and that's why we requested this meeting every other week that includes both federal and state staff and our staff, and that has moved projects pretty expeditiously, and we don't want to lose that. We want to maintain that, obviously.
The total amount that we've requested from FEMA is over 400 million, correct?
It's about 480. It actually is probably between 468 and 480, because there are certain questions about the whether certain claims qualify, but it's around that range, Supervisor.
And we have received so far from to the state, FEMA has paid them about what, 260, 270 as of now?
We have received obligations that range in the mid 250, about 240 million to 50 million.
Interruption, gentlemen. Mr. Campos, the word obligations is a term of art. Could you just tell everybody what it means? Is
Sure.
that money? Is that a check? What is that?
Obligation means that the federal government has reviewed the claim and has decided that we are owed that money. And so that means it has been approved by the federal government, and within a short period of time of obligation, the money is then sent to the state. But it's not money that we receive. We are in the process of figuring out how much of the new money, the new 200 million or so that has been obligated, has been received. In fact, we have a meeting later today with our staff to figure that out, so that we can focus on the specific amount that remains of what has been obligated, so that we can have a strategy for how to move that forward and a timeline for when the money will come. And so obligation means approval by the federal government, but not a check to us yet.
Don't spend it yet. Back to you, Supervisor Lee. Forgive the interruption.
So going back to the number, you said 468 to 480 is what we have applied for. We got approved, basically IOU of about 250 or so. So given my rough math, looks like we still at least 220 old on this potential IOU you're going to look at. And you mentioned earlier that none of that would proceed unless there's like more funding to FEMA?
So we have about 240, 50 million that has been obligated. Of that, we have definitely received 55 million before. And we have about 200 million that has been obligated that we're waiting to receive from the state. So about 200 million or so that we are working to get from Cal OES in the very near term. And then we have an additional 200 million plus that we're working to receive additional obligations from FEMA. It is that piece that will not take place unless there is additional funding for FEMA. And the one thing that I would note, and this is good news for us and the work of our team, is that of that 200 plus million that remains to be obligated, we have close to 100 million where the claims seem to be moving pretty quickly. And so they're in a very good position that if the funding comes through from the federal government, that we can see an obligation in the near future. So we're cautiously optimistic and hoping that the continuing resolution that is approved later this month will include FEMA funding. Mr. Pike and others will have a better sense of whether or not that is likely to happen, but we're cautiously optimistic that this is one thing where both Republicans and Democrats would agree that funding FEMA is a priority.
Mr. Pike, let me pull you in if you'd like to be pulled in.
Absolutely. And thank you, Mr. Campos. Well, I think one of the primary reasons I attend on behalf of the congressman is to be able to understand the needs of the county and how we can be responsive. And in this case, certainly, I'm happy to hear about the benefits of the previous work that the four San Jose delegation in Congress has done, but also I will be sure and convey to not only my boss, but the other offices, the ongoing need to, refill the pot for the fiscal year 25 budget to get the FEMA money, and then please let us know whatever else we can do to help out in the interim. But we worked together on this last year, and it's good to see it's at least moving in a positive direction, but we're here to help.
Thank you
Thank you
very
very much. And unless you have any questions, I will proceed now to the presentation from our Prime Policy team. And I also want to acknowledge the work that Prime has done in assisting us in this effort. And we are joined via Zoom by the Prime team that is led today by Rich Mead. We also have Aquila Powell and Ann Adler, and they're going to provide a general update on the federal budget. Again, we're very grateful for all their work, and there's a lot of uncertainty at the federal level, so they're going to provide clarity for us. So, Prime team.
Thank you, Mr. Campos, and thank you, Supervisors Lee and Smithian. It's a pleasure to be here with you this afternoon, morning for you all. But let me start my presentation by introducing our newest member of the Santa Clara team at our firm, Ann Adler. Ann has extensive experience both on Capitol Hill and in the agency. She worked at the Department of Interior, where she worked on a lot of conservation and environmental issues. But Ann is a real expert in the appropriations process, having served as the Chief of Staff for one of the longstanding chairman and ranking member of the Appropriations Committee in the Senate, Senator Robert Byrd. So with that, I just want to introduce Ann, and then I'll proceed with my report.
Thank you very much. Welcome.
I'm going to give you just a general and brief overview of what's happening in Congress, and then I'll allow Ann to dive in on the appropriations process with particular emphasis and focus on the need to pass a continuing resolution by the end of September to make sure the federal government remains funded. Let me just start by saying that before Congress left for their August recess, the Senate passed two significant online safety bills for children: the Kids Online Safety Act, or KOSA, and the Children and Teens Online Privacy Protection Act, COPA. COSA establishes what we call a duty of care for online content accessed by children, and also gives children the option to opt out of the most addictive product features offered online. COPA, I should also say that COSA also empowers the Federal Trade Commission to review and look at content put out online and targeted towards children. COPA prohibits companies from collecting the data of teens who go online. It also prohibits targeting ads specifically towards teen online users. Both these bills passed the Senate by an overwhelming vote of 91-3. It's not clear whether the House will take both bills up, but given how popular they were, they're likely to consider them, but probably not before the elections. Instead, the House has been focused on a lot of sort of political bills, most of which is focused on sort of, the desire for the House to think that they are looking tough on trade issues with China and other trading partners, and some other political bills as well. So that's been their focus. And so we don't expect between now and the time that Congress leaves for the elections for much real legislating to be done in the Congress. However, they are sort of setting up for a very robust, what we call a lame duck session, a session of Congress that's going to be held after the election. And they will definitely need that session because they're not going to likely wrap up the appropriations process before adjourning for the elections, and rather pass a continuing resolution to keep the government open. And we've been keeping sort of a running list of some of the issues that are likely to be considered during this lame duck session. And let me start with the first one. And there's a bipartisan legislation to reauthorize water projects known as the Water Resources Development Act, WRDA. And we did hear from the county about this because they got an inquiry about this bill, and in particular about a study that was required in one version of this bill to look at the Army Corps of Engineers policy towards homeless people who try to encamp on the Army Corps of Engineers land. The current policy of the Army Corps is they don't let homeless to encamp on the lands they control, and so this study will revisit that issue at a minimum. Now, whether the study can reverse that policy or not, that's yet to be seen, but nevertheless, it's a step in that direction. Another issue for consideration during the lame duck session is the Farm Bill, where you have the Senate Agriculture Committee Chairwoman, Senator Debbie Stabenow of Michigan, is not returning at the end of this year to Congress, and so she's considered sort of a lame duck chair. And if the House Representatives flips, then the House Chairman, G.T. Thompson from Pennsylvania, would also be a lame duck chair. And there's potential with those two lame duck chairs for them to resolve the issues and get a farm bill done under their signatures before they lose their chairmanships. The biggest sort of stumbling block right now over getting the farm bill is that the Republicans in the House want to limit or cut spending for a lot of nutrition assistance programs funded by the Farm Bill, the most significant of which is this Supplemental Nutrition Assistance Program, or SNAP, whereas the Democrats want to potentially expand those programs or at a minimum maintain them. And one of the areas that they're looking at possible expansion is to bring the SNAP program to the island of Puerto Rico, which has its own sort of ad hoc nutrition assistance program currently that's not very sufficient. And Mr. Margolin mentioned a lot of the outstanding health issues and the need for continuing a lot of these healthcare funding sources, which is likely, I think is likely to happen. As he mentioned, there's bipartisan agreement to do so, but there's some other health issues that may be packaged with those healthcare extensions, starting with, and he did make mention of the need to extend the telehealth authorities under the Medicare program, which were put in place during COVID and allowed to continue to the end of this year, but the desire to continue them further. There's also an interest in trying to add more transparency to to how what we call the pharmacy benefit managers, the third parties that administer the drug benefit programs, add more transparency to how they operate, because there's a feeling that perhaps they take too much money from the drugstores, and therefore the consumers don't see any of the savings from that directly. And then finally, there's also an issue in potentially restoring some of the money for physicians that is being proposed to be cut in a rule passed by the Centers for Medicare and Medicaid. So all those issues are likely to come and be addressed in the lame duck session in some form or fashion. But as I always say, the lame duck sessions are like the Wild West, in that anything can happen or nothing can happen. We don't know yet how much will get done or won't get done. So with that, let me turn to Ms. Adler for her discussion of the appropriations process and the continuing resolution specifically.
Thank you very much.
Hi again. Thank you very much for the welcome. I'm really excited to be working for Santa Clara County. As has been noted several times during this meeting, the fiscal year will end September 30th at midnight. And in order to keep the government operating and prevent a shutdown, Congress will need to pass the 12 appropriation bills, either through some small packages or, which we all know is really unlikely, or we'll have to pass what we call a continuing resolution. So the continuing resolution typically, and in this case we believe it will, continue to fund the government at current year levels for a set period of time. It can be days, weeks, or months. But last week, the House was set to consider a continuing resolution that was advocated by Speaker Mike Johnson that would fund the government through March of next year. His bill included provisions of the SAVE Act, an act that would mandate that states adopt restrictive identification requirements for individuals registering to vote. It's an issue that's come up repeatedly, and different bills have been advocated repeatedly over the years. It's truly a nod to conservative members of his Republican wing, but ultimately the Speaker wasn't able to get enough Republican votes to pass the CR. And meanwhile, Democrats objected not only to the SAVE Act, but also to the March end date. And so that bill failed. And we had heard earlier this week that, when the schedule came out for the House, there was only a mention that a CR, a continuing resolution, could be on the schedule, but there was nothing actually scheduled. We had also heard that the expectation was that the House had pretty much just thrown in the towel and was going to allow the Senate to pass a continuing resolution that the House would then take up and pass, and that everybody would be leaving town. But just in the last hour, word has come out that Speaker Johnson is going to try to bring his CR to the floor again tomorrow. We don't have any information yet about whether or not he has support. The early stories that have come out continue to think that he doesn't have enough Republican support to pass the continuing resolution, largely because a number of particularly conservative members in the Republican Party feel that whether they pass it or not, the Senate will not accept the bill as it is and will pass what we call a clean continuing resolution, which would not include the SAVE Act. And so we're going to have to wait and see what happens. But if things go as we currently predict, we expect that the Senate will pass continuing resolution perhaps later this week, and it's expected to be a clean bill with no authorizing measures attached to it that would keep the government open until Friday, December 13th. And once the Senate acts, we do expect that the House will probably pass that bill on a bipartisan vote with Democratic support. The House Committee Appropriations Chairman, interestingly, was recently noted that he supports the idea of a CR that lasts until December, and he's been quoted as saying, "I don't think we should leave the next president, whoever it is, with a funding crisis that they'll have to deal with when they walk through the door." So that's important and interesting and valuable to hear that Republican chairman of the House Committee, Tom Cole, is supportive of the concept of a continuing resolution that goes until sometime in December. So that would mean then that the government would stay open until midnight December the 13th, and we would be facing the prospect of another potential government shutdown unless we pass appropriation bills, all the appropriation bills, or another continuing resolution. What ultimately happens will obviously be affected by the outcome of the elections. Everybody's on both sides of the aisle looks at the election to determine whether or not they think it's to their political advantage and their funding advantage, funding their own priorities, to determine who has control of the House, who has control of the Senate, who has control of the White House. And so we'll have to see what happens, how the election impacts the appropriation bills. But I suspect that Congress will pass a few of the regular appropriation bills before that December 13th deadline. The most likely, I think, being defense and veteran affairs and military construction. It's one bill that funds veterans affairs and military construction, in part because there's always a lot of support on both sides of the aisle for defense appropriations, and the funding is needed. And there's always a lot of support for veterans, and the House and Senate have had to address a funding shortfall for veterans through the end of this year because of a miscalculation by the Department of Veterans Affairs through a temporary supplemental. So I think those are two bills that are likely to pass. Homeland Security is a possibility simply because of the FEMA situation. We know that FEMA is basically out of money, and they're reserving what money they have to address current emergencies and natural disasters. But that bill will bring some political opposition because it also funds border security, and so we'll have to see what happens. But the rest of the government is likely then to be funded through another short-term CR, and we'll continue down that path of trying to either pass the bills individually, or more likely end up passing some kind of a minibus that would include the rest of the appropriation bills at some point, either later this year or early next year. I will note, having worked for the Appropriations Committee chairman, there's nothing like December break to get appropriation bills passed. That is typically when we see the most action and the highest likelihood that we can get appropriation bills passed, because members want to get home for the Christmas break. And they're usually pretty tired and disgusted by then. And we're also in a lame duck situation, so we'll have a new Congress next year that will have to take this up. A few important thoughts that I think are helpful. A continuing resolution doesn't include funding for any new programs, nor does it include earmarks or what we're now calling community projects that were contained in the current fiscal year bills. While operating under a continuing resolution, federal agencies are usually really cautious about their spending because they don't know whether or not they're going to face another government shutdown, or when or how much money they're going to get. So they will reserve funding for a period of time until some of this, until they have more clarity on that. Agencies then are also reluctant to issue contracts because they, again, don't know what funding they'll have. They usually do issue some contracts, but there's a process that they go through to determine those most necessary for them to issue right away. And then also, it moves rather slowly. The contracting process moves rather slowly. So all this means for all of us, for the nation, but for states and counties and local governments, that we're left with a significant amount of uncertainty that makes it really, really impossible to plan layouts, outlays of funding projects and programs going forward. The best outcome for Santa Clara County and for the nation would be for us to be able to pass all 12 appropriation bills, either individually or more likely in some kind of a package before the end of the calendar year, so we can start our new year knowing what kind of funding we have and when it will be available.
Thank you very much. A lot of twists and turns.
Yeah.
Supervisor Lee, any questions?
Yes, thank you. Welcome aboard, Ms. Adler. Looking forward to working with you and with your tremendous experience. We're looking forward to a lot of good work we could do together. So On this continuing resolution CR that we talk about, since we only have, what, 13 days left in the
Right.
calendar, the fiscal year, right? So the urgency is now, and the way I understand it is there seems to be three factions. Hopefully what we would like, or many people are hoping, is that let's make a CR be a clean CR, just extend the current spending basically, right, based on that, while other things get dealt with separately. Right now, the proposal from the House leadership, the House Republicans, is basically a CR, but it's loaded with cuts that the right wing would like on those issues. And then the third faction that I see is, I read something how the current Trump and Vance, they actually want to have a shutdown. And so I just want to see how likely is that win going to actually prevail at the end of the day if we're not going to, I mean, actually, with somebody advocating for shutdown with that type of a leadership, I'm concerned that, is that a real risk, or do you think something would pass eventually?
I think it's unlikely. Let me clarify that the continuing resolution that has been proposed by Speaker Johnson does not include deep cuts. It is continuing funding, but it does include this SAVE Act provision that people are really unhappy with, and it does include a March date, which isn't the best for trying to pass appropriation bills. It really doesn't add pressure to the members to get together and actually pass appropriation bills, and then it leaves it to another new Congress. But I think it's unlikely because, again, the Republican chairman of the House Appropriations Committee really does support moving these bills. He's a little old-fashioned and less on that very conservative wing of the Republican Party. And I think that both Democrats and Republicans in the House will rally together for a clean CR. So I don't think we're going to have a government shutdown, at least not not on October 1st.
You mentioned the Senate's going to take action on a clean CR separately. So if, let's say, even the both of these passes, then would they go to some type of conference to bring back to each body? Is that how that's going to work?
Well, technically, yes, that would happen, but I still think it's unlikely that the House will pass this particular appropriation bill. I do think that the Senate will probably pass its bill. And what the Senate sometimes does to the House, and I wouldn't be at all surprised to see it happen this time, is they'll pass a continuing resolution and leave town. And so leave the House with little choice but to pass the bill that's already been passed by the Senate.
Right. Okay. So that's all the political game playing we'll be watching in the next 13 days, I guess. You did mention something about earlier on the cutting of the SNAP program, which of course that's talking about cutting food stamps. Is that something that we are dealing with on this CR, or this is just something that we're looking at further down the pipeline?
Supervisor Lee, that's something I mentioned that's at play with the Farm Bill. Since the SNAP program is considered a mandatory spending program, meaning the dollars flow automatically from the law, it's not subject to the appropriations, so the CR doesn't impact the level of SNAP funding directly one way or the other. But like I said, the Republicans were pushing to restrict those benefits within the Farm Bill, although the Democrats and the Senate broadly do not support doing that. So it's probably not likely to go forward, but it's being proposed in the House version of the Farm Bill.
Okay, thank you for that clarification. And the last issue is what we talked about earlier regarding FEMA funding. So is the FEMA funding and the veterans funding that we talked about that was discussed, are those going to be separate legislation to pass, or is it all going to be part of the CR?
Well, the CR will cover the entire government, but there are 12 different appropriation bills that fund different parts of the government. And individually, FEMA is funded in the Homeland Security Appropriation Bill. Veterans is included in what we call the MILCON VA bill, the Military Construction Veterans Affairs bill. So they're separate bills, but again, they will be wrapped up in a continuing resolution that will continue this funding. We'll have to address the individual bills themselves later when we take up either probably some kind of an omnibus bill that will include a lot of bills, or separate, what we call minibuses that may wrap 2 or 3 bills together to get them passed.
So they are separate bills, but they will be wrapped together as a package deal at the end of the day for passage.
In the continuing resolution, yes, absolutely. And probably at some point later this year, when we deal with the fiscal year appropriations for the coming fiscal year, which starts October 1st.
Great. Thank you. Clear as mud.
I
But
know,
this
I'm
is
so
exactly,
sorry.
no, it's not you. It's just how convoluted how Congress do things. And it's unfortunate. I'm so glad our county, we don't do things that way. Thank you. And that's all I have, Chair.
All right, on that note, I have no additional questions, so thank you very much. Let me look to the clerk to check in on whether or not we have any speakers on this item.
We do not have any requests to speak.
Thank you. So let me ask if I can get a motion to receive the report.
So moved.
And motion by Lee, second by Semidian. Let's call the roll.
Vice Chairperson Lee?
Aye.
And Chairperson Simidian?
Aye.
Thank you.
And that was item 6, I believe, yes? Well, 6 and 7. Did we blend the two?
I believe we had a clean break for 6 and 7,
All
and you
right.
had motions passed
All
for
right,
both.
good. I just want to make sure that we have a clear record for the clerk's office to parse. All right, then that will take us to the end of the meeting, unless there's one last thing. Seeing and hearing none, and without objection, and I don't think there is any, we stand adjourned until our next meeting, which I believe, Madam Clerk, is November the 20th. Does that sound right? All right, we are adjourned. Thank you all very much.
Thank you.
Go make the world a better place, everybody.